Welcome to Law Sessions. I'm Jennifer Housen. In this law session on the English legal system, we will be exploring the topic of judicial reasoning. In particular, we will be looking at precedents. Now, in a separate law session, of course, we've done statutory interpretation, but what we're looking at here is the judge-made laws, or rather the cases and how judges reason when they are dealing with cases. Now, you can get questions in English legal system or common law reason and institutions which ask you things like, do judges make law? Now, the point, of course, is that when you are going to answer such a question, you need to know what precedent is, and then, based on that, you then apply it in a manner that will allow you to have a full discussion as it relates to precedent, how the process works, and why there are commentators who say that judges make law. Now, when you look at judicial precedent, it is the process where judges follow previously decided cases where the facts or the points of law are sufficiently similar. When you look at the doctrine of precedent, it is a unique feature to the common law system. It is unique to the common law system. So when you look at, for example, a contrast with, say, the civil law jurisdictions, you don't have this doctrine of precedent. Now, it is a concept almost unknown to civil law jurisdictions when you look at, for example, France and Germany. Now, the essence of the doctrine is encapsulated in the stare decisis principle, which speaks about let the decision stand. And what that means is that the rule that a decision from a previous judgment will be followed in circumstances where there are similar subsequent cases, and what that allows for is that it gives a degree of certainty, consistency, and clarity in the law. Now, the idea is you may very well get a question which says precedent has a twofold basis, or it may be that precedent has a dual role. It allows the law to be consistent and certain and clear, whilst on the other hand, it allows such degree of flexibility to allow the common law to develop. You have to know how to deal with the both of them. So based on what we're saying here, it is that when you consider precedent, the main thing about it is that it is about like cases following previously decided like cases to give certainty, consistency, and clarity. So the view is that where you apply on a consistent basis like rules to similar decisions, then this could be the premise, the basis on which you could use it to predict a court's possible approach in a particular case. In fact, when you look at the hierarchy of the court, so when you look at the court system's framework and the respect by the lower courts of the decisions of the higher courts, together with the fact that there is an established regular system of the publication of law reports, well, these have allowed this doctrine of precedent to develop and mature. So the system of law reporting allows you to be able to see the cases and so on. And certainly when you look at, for example, the way that lower courts will respect higher courts' decision, that certainly is a factor. Having said that, though, there has certainly, when you look at the background, there has certainly been judicial activism. And in fact, I have reserved the final segment of this law session to look at Lord Denning, one of the more impressive judges when it comes to how he approached the law, because you see a degree of intellectual activity that is, I wouldn't say not seen among other judges, but he was more willing to go out on a limb, if you like. So Although we see this consistency, we do know that there is active judicial decisions or judicial activism where the judge will grasp the nettle and deal with it. And we do see this, of course, also when we look at statutory interpretation. We do see that judicial activity because it is for the court, of course, to interpret a particular piece of legislation. With this kind of judicial activism and the way that statute is interpreted has allowed the common law to develop, while of course at the same time touching on this whole traditional notion of precedent. Now, the basis of the law in the UK today is predominantly case law. There's a mass of judge-made decisions which lay down rules which are to be followed in future court cases. Now, as well as being a source of law in their own right, we see acts of parliament which also contribute to case law, since the courts have to interpret the acts, and such decisions again lay down new precedents. Delegated legislation is made by an administration rather than the legislature, and certainly lays down detailed rules to implement the broader provisions of an act of parliament. Now, when we look at the doctrine of stare decisis, it grew up over time. So whenever a new problem of law came to be decided, the decision formed a rule to be followed in all similar cases, making the law somewhat predictable. Now, the result of all this was that a common law had been produced that ruled the whole country, and that the idea being it would be consistently applied and could, as I say, be used to act as a kind of gauge as to what a future court might decide in a particular case. Now, it contained many of what are now basic points of English law. So, for example, the fact that murder is a crime was borne out in the common law. When we look at the principles behind this common law that is used today in creating case law, it all goes back to that. Now, when you look at the basic idea of stare decisis, you have a hierarchy of precedent which has grown up in line with the hierarchy of the modern court system, so that in general a judge must follow decisions in courts which are higher up in the hierarchy than his or her own court. Now, this process was made easy, of course, by the establishment of a regular system of publishing reports of cases in the higher courts. Now, the body of decisions made by the higher courts, which the lower courts must respect, is of course that bulk of case law that has come up. And it was made by judges, which of course came out of the cases before them. So what we get are the judges listening to the cases, making a decision, looking at the facts, interpreting them, and then of course making a judgment whereby it can then certainly be looked at later on. So he listens to the evidence and the legal arguments, and of course he will then make a determination as it relates to the case before him. Now, the explanation of the legal principles on which the decision is made is called the ratio decidendi, and it is Latin for the reason for deciding. It is this part of the judgment, the ratio as it is normally shortened, which is known as binding precedent. And this is what forms the crux of case law. So the ratio is what a future court will look at in order to bind itself or be bound by that part of the judgment. Now, all the parts of the judgment which do not form the ratio of the case are called obiter dicta. Again, a Latin term for things said by the way. In deciding a case, a judge must follow any decision that has been made by a higher court in a case with similar facts. Now, the rules concerning which courts are bound by which are known as the rules of judicial precedent or stare decisis. As well as being bound by the decisions of courts above them, some courts must also follow decisions made by their own court, so previous decisions of that same court. And in that circumstance, they are said to be bound by themselves. So in order to understand this, let's briefly consider the structure and hierarchy of the courts in England and Wales. I want to dispense first with the European Court of Justice, or the Court of Justice of the EU as it is now known. The thing about the Court of Justice of the EU is that it deals with matters within EU competence, which is the four freedoms, which are the free movement of goods, free movement of workers, free movement of services and establishment, and of course capital. So the idea is that if you are going before your own national court in relation to a matter that is of an EU competence, then of course the case law of the Court of Justice of the EU is relevant. So decisions by the Court of Justice of the EU on the interpretation of, for example, the European Treaty, the validity of acts of community institutions, interpretations of the statute of the council bodies, are binding, of course, on English courts to the extent that it has, of course, to do with EU law. Now, it appears that the Court of Justice of the EU is not bound by its own decision. But as I say, please bear in mind that the Court of Justice of the EU and the body of EU law, the jurisprudence of EU law, is only able to impact on UK law simply because the UK, by virtue of the European Communities Act 1972, has taken on board that EU law is, for all intents and purposes, supreme if there is conflicting national law. Let's then focus on the real courts, as it were, in the UK itself. We start off with the highest, and that's the Supreme Court, formerly known as the House of Lords. Well, apart from cases concerning EU law, this, of course, is the highest appeal court on civil and criminal matters, and all of the English courts are bound by decisions of the Supreme Court. Now, in 1966, by way of a practice direction, the House of Lords, as it was then known, said that it is no longer bound by its previous decisions. This makes sense, of course, because if it was bound by its previous decisions, it means that the law would have or appear to have some difficulty in being developed, because then it couldn't go outside of a judgment that was previously made. In practice, the Supreme Court only rarely overruled one of its earlier decisions. Alongside the Supreme Court framework, of course, is the Privy Council, which was, of course, established by the Judicial Committee in 1833. It is the final court for many Commonwealth countries, and its decisions are only influential on British courts and not binding. The point, of course, being that even though it's the same law lords, as it were, sitting, the decisions are really not binding on the Supreme Court. But having said that, please ensure that you look, for example, at certain cases. For example, in criminal law, there are a couple of cases. Look at Attorney General for Jersey and Holly, because this case, albeit a Privy Council case, did have remarkable impact when you looked at the idea of provocation and the like in the context of whether the courts were bound by it or not. But look at it. So sometimes the Privy Council decisions may very well have more teeth than you think some people think that it does. The Court of Appeal is split into civil and criminal divisions. They do not bind each other. Both are bound by the Supreme Court. The civil division is usually bound by its own previous decisions, but there are certain exceptions, 4 exceptions in fact, and they are that the previous decision was made in ignorance of a relevant law, so it is said to have been made per incurium. Secondly, there are 2 previous conflicting decisions. You can choose which one to follow. Thirdly, if there's a later conflicting Supreme Court decision, you can follow that. And fourthly, a proposition of law was assumed to exist by an earlier court and was not subject to arguments or consideration by that court. The main case when you're looking at the Court of Appeal, of course, is Young and Bristol Airplane, because it allows you to understand it. Now, in the criminal division of the Court of Appeal, we see the results of cases heard may decide whether or not an individual, of course, loses his liberty, so whether he goes to prison. So the criminal division takes a more flexible approach to its previous decisions and does not follow them where doing so would, of course, cause injustice. The High Court is divided between the divisional courts and the ordinary High Court. All are bound by the Court of Appeal and the Supreme Court. The divisional courts are the Queen's Bench Division, which deals with criminal appeals and judicial review, the Chancery Division and the Family Division, which both deal with civil appeals. Now, the two civil divisional courts are bound by their previous decisions, but the divisional court of the Queen's Bench is more flexible about this for the same reason as the criminal division of the Court of Appeal. The divisional courts bind the ordinary High Court. Now, the ordinary High Court is not bound by its own previous decisions. It can produce precedents for courts below it, but these are for a lower status than those produced by the Court of Appeal or the Supreme Court. That gives you an idea of the hierarchy up to the High Court. I'm going to take a short break, and when we come back, we will look just a lower bit down the rung of the ladder and start off by looking at the Crown Court, the County Court, the Magistrates Court, and we will carry on in respect of precedent.